The Committee on Housing and Homelessness Prevention will come to order. I will note we do not have a quorum yet. We will start with a presentation of the cooperative manufactured housing, about cooperative manufactured housing in Minnesota. We will hear from Emily Stewart, Associate Director of CoNorth. Ms. Smith, Stewart, apologies. Welcome to the committee. Please introduce yourself and begin.
Good afternoon, Chairport and committee members. I'm Emily Stewart, the Associate Director of CoNorth, formerly known as North Country Cooperative Foundation. Thank you for the opportunity to share insights on the state of manufactured housing in Minnesota and the role our organization plays in preserving this critical source of affordable homeownership. There are actually 8 members of the committee that have 4,512 units of manufactured housing in their district, underscoring that manufactured housing is not a niche issue, but a critical component of affordable homeownership across Minnesota. CoNorth is a nonprofit organization that's based in St. Paul, dedicated to expanding cooperative ownership and economic opportunity. Since the early 2000s, we have focused on helping residents of manufactured home communities, commonly referred to as mobile home parks, purchase the land beneath their homes and convert their communities into resident-owned cooperatives. In addition to cooperative development, we provide ongoing advising and coaching to ensure these communities thrive, helping residents with governance, management, and financial sustainability. In 2023, we created a loan fund to provide mission-driven lending solutions to our partner cooperatives, and we recently launched a manufactured home dealership to ensure that our cooperatives have access to high-quality factory-built homes. Since 2004, we've helped 18 communities, 15 of which are in Minnesota, transition to cooperative ownership. Through this work, we've gained a deep understanding of what it takes to permanently preserve these communities and the challenges they face. With the legislature's support, we've made significant progress in building a strong set of tools to protect these communities for the long term. Manufactured housing is Minnesota's largest source of naturally occurring affordable home ownership, serving over 180,000 residents. For many, it's the only pathway to owning a home. While there are misconceptions about manufactured home communities, the reality is most residents, 87%, own their home. The only thing the residents of these communities rent is the land beneath their homes. New manufactured homes are cost-effective, they're energy efficient, and they're durable, while costing about half as much to construct than a site-built home or a single-family home. Preserving these communities is also highly cost-effective, with infrastructure and rehab averaging about $10,000 to $50,000 per unit, far less than other affordable housing solutions. Manufactured housing is also found all across the state and serves a very diverse population that would otherwise struggle to find affordable homeownership opportunities. 75% of the residents in our partner cooperatives earn less than 60% of area median income, and about 40% are households of color. Historically, manufactured home communities were locally owned and operated. Many were developed by small business owners who lived on site or nearby and were invested in the well-being of their residents and the property. Over time, investors have identified an opportunity to profit from these communities. Investors have found that they can raise the land rent without substantially reinvesting in the infrastructure. Bloomberg did a report on this, and they declared that manufactured home communities was the fastest appreciating commercial real estate asset over a 10-year period, 2010 to 2020. It appreciated by 478%. Which is an astronomical number, 478% in terms of appreciation. And I'll just note that commercial real estate properties do not appreciate in value based on necessarily the investment that you're putting into the property, but it's truly based on the revenue that can be generated. So that 478% appreciation is on the back of the homeowners that are paying that lot rent or that land rent. Since homeowners rent the land underneath their homes and the cost to move a home is prohibitively expensive, homeowners have little choice but to pay increasing rents imposed by oftentimes corporate landlords, even when roads, water, sewer systems are neglected. In investor-owned communities, lot rents typically raise by 6% per year, and in contrast, our resident-owned communities that we serve typically increase about 2% per year. In resident-owned communities, homeowners collectively own the land through the cooperative. Their land rent goes towards running the community, paying the mortgage, and making needed improvements. Most importantly, resident ownership means stability. There's no risk of a sudden sale or displacement, ensuring these communities remain a permanent source of affordable homeownership. I'll also note that homeowners have an opportunity for their home to appreciate because of that stability as well. Many manufactured home communities rely on aging, privately owned infrastructure, water, sewer, roads, electrical systems, most of which were built in the 1950s and 60s with a 60-year life. Without investment, these failing systems put entire communities at risk. Recognizing this urgent need, the legislature established a manufactured home community redevelopment program that we refer to as the MHCR. And since 2020, $44 million have flowed through that program for grants for privately owned and resident-owned manufactured home communities across the state. The next slide highlights a project funded through the MHCR program. Zumber Ridge Estates in Rochester, located in Senator Bolden's district, demonstrates the impact of state-appropriated funds through this program. Major infrastructure improvements were completed in late 2024, beginning with a full road and drainage upgrade finishing in early November of this past year. All roads in the community were repaved, new slopes, curbs, catch basins, and culverts were installed to better manage stormwater, reduce erosion, and protect both roadways and nearby homes. In addition, the community made critical upgrades to its sanitary sewer system in fall of 2024. I'll also note that Senator Gruenhagen has had $1.8 million of investment through this MHCR program in their district, and Senator Draheim has seen $3.5 million in investment in their program, along with Senator Bolden with $3.8 million. I'll also note that Senate File 1775 this year is a $15 million appropriation through HIBS for the MHCR program for the upcoming RFP this fall. Minnesota cannot afford to scale back investments in manufactured home community infrastructure. There's too much at stake, and the demand continues to grow. Thankfully, Minnesota has many existing programs that can be leveraged to expand access to infrastructure improvements. A major challenge for manufactured home communities is also the rising cost of homes and the lack of affordable financing. In the last 10 years, the cost to build a new manufactured home has more than doubled, yet financing options remain limited. Manufactured homes are leased on leased land, are titled as personal property, and they don't qualify for traditional 30-year mortgages or most down payment assistance programs. Instead, buyers are left with personal property loans with shorter terms and higher interest rates similar to auto loans. Recognizing this gap, the state legislature took an important step in 2023 and appropriated a $10 million direct appropriation to develop an innovative manufactured home loan product, helping manufactured home ownership more accessible for these new homes. Through our partnership with NeighborWorks Home Partners, the institution that has this direct appropriation, they've developed an incredibly innovative product. They've modeled it after successful programs across the country. And their loan product features a 30-year term with competitive interest rates, bringing manufactured home financing in line with traditional mortgages for the first time. It's also paired with a brand new home buyer education course developed in partnership with the Minnesota Homeownership Center. This program is a game changer for manufactured homeowners in Minnesota and will bring homeownership within reach for hundreds of families. These homes sell for on average $100,000 to $150,000. I'll also note that there's a Senate File 2681 for a $5 million direct appropriation to add to the pool for down payment assistance to pair with this product. Manufactured homes on leased land are legally treated as personal property, like vehicles, as I mentioned. This classification blocks access to traditional mortgages. Homeowners are pushed into higher personal property loans with fewer consumer protections. Title reform aligns with a legal framework with how manufactured homes actually functions as permanent housing. Title reform will unlock lower cost Fannie and Freddie mortgage products, which will strengthen housing stability without without more subsidy. Let us know if you'd like to be part of the legislative working group that we are putting together around title reform for next year. The final issue I want to highlight today is the rapid shift in the ownership landscape of manufactured home communities, which I mentioned earlier with the fast appreciation over the last decade. I'll note since 2015, out-of-state investors have acquired nearly 30% of the state's manufactured housing stock, including 142 communities, which represents 13,533 homes. I want to highlight a couple of recent park sales that happened that went to actually private equity, specifically Haven Park Capital, Zenith Terrace in Duluth, about 500 units in that community sold for $44 million, which is $11 million over its value. And in this past December, in Brandondale Estates in Chaska, another 500-unit community thereabouts, went for $40 million, which was double the appraised value of $24.2 million. The impact to residents, particularly in the Chaska property, is that they've seen their lot rents increase or land rents increase by nearly 65%. A significant portion of these acquisitions have been made by private equity firms since 2015, since we've been tracking sales. And these are really remarkable and concerning numbers, which I think highlights the urgency of this issue. To make matters worse, federally backed entities are fueling these acquisitions, 2/3 of which private equity purchase have been financed by Fannie Mae and Freddie Mac. Seeing the urgency, the legislature took an important step and they appropriated a $10 million fund to CoNorth to establish a revolving loan fund for cooperative purchases. We've been able to leverage the $9 million in lending capital from the state appropriation with an additional $3.8 million in low interest capital for a $12.8 million low interest capital fund. These are mission-driven loans averaging about 4% interest. We've deployed $6.8 million to preserve 448 home sites across 8 communities, and we anticipate an additional $5 million in deployment this year. Let's see, fast-acting capital remains the most critical tool we have to scale preservation of these communities and prevent displacement. The legislature also passed a notice of sale law in 2023 requiring community owners to notify Minnesota Housing and the community residents when they're considering a sale. A 5% tax credit was also passed for community owners who sell to cooperatives, nonprofits, and municipal buyers. The intent of these laws were to give preservation-minded buyers a chance to compete when communities are for sale and to provide an incentive for owners to sell to non-for-profit organizations. Since the law went into effect in July of 2023 through December of 2025, Minnesota Housing has received 8 notices that have gone to sale, yet 42 sales have occurred during that time. In most cases, when notices do happen, it's too late because the property is already under contract. This past fall, we were able to reach one owner before that property went under contract, and we converted that community to cooperative ownership this past December. It's clear that additional awareness and enforcement are necessary to ensure these laws achieve their intended results. Thank you for your time today. That's my presentation.
Thank you very much. Members, any questions? All right, seeing none, thank you so much. We will next move to Senate File 4909, Senator Abeler. We'll continue on the topic of manufactured housing. When you are ready, Senator Abeler, you may present your bill.
Thank you, Madam Chair. It's like a sellout audience. I think if people understood the challenge of people that live in the mobile home parks, manufactured housing parks, they would be angry. For the report we just got, where more and more, I mean, God bless capitalism, God bless investors. They do a lot of good things in America, but sometimes they see an opportunity. And being on this committee, I've become more aware than ever about some of the inequities, not just on a socialistic basis, like, oh, everybody should get their chance, but just unfair treatment. If you're little enough, there's no way to really have a champion, except for maybe us. Anyway, and so I was quite surprised to hear what everybody knows that's on this committee and the people in the audience, that you can lose your mobile home really in a very short time, and they can, even if you, after about 3 months, they can demolish it for you and then complain about having to haul away the debris. And so, Madam Chair, if one of the testifiers is one of the promoters, I'll let them explain the bill. I can do that, but I don't want to do, like, we can save time that way. But with this, so if you want to get them up. So go ahead, you can say that.
Very good. You're ready to bring testifiers up?
Well, just if the proponents of my bill, and then they can, I think in that conversation, I'll just stick with a philosophical start, and they can.
Very good.
I mean, I can read you the whole thing if you want, but it's going to come out in the testimony. But
very good. Let's move to testifiers.
Yeah, but I'll keep talking until they come, Madam Chair, if you don't mind.
Of course. I will also note that we do now have quorum. So I will ask to come forward Jillian Christensen and Aaron Lambert.
Anyway, so So I
Senator
asked
Abeler.
the advocates, is there some way we can protect the equity of these people? And so I, toured my local one, and they said, well, in about 3 months, we can lose our home that we spent $180,000 for and have nothing to show for it, which really troubles me. And so this creates, I'm just interested in some of the pushback, and we'll discuss the bill, but this is like one of the biggest things they own is their home. It's their home, and it's their place. They raise their kids, they have a little park, they have neighbors, and this is where they live. And then things get bought out, and now a third of them are owned by some kind of equity outfit, and so their prices go up, and they're just in harm's way, and they're challenged anyway. And to make a $800 a month payment is oftentimes very challenging for these individuals. And so they get a little behind on that, and suddenly they have nothing at all. And so this is the bill that tries to set some of that right. And Madam Chair, just talking to some of the very kind opponents in the hallway, I know how to find some consensus somehow. But the way it is, I think, is just inadequate. And so this bill has to go to judiciary, which is the same as just letting it, might as well send it to the Saudi, to the Gobi Desert. And so perhaps if there's something we can do at the end of our markup time, if there's some way it doesn't require the judiciary parts, that is maybe not a consensus, but does something to help give relief to these good people, I would love that, Madam Chair. So with that, I'll let my testifiers carry the load.
Welcome to the committee. Whoever would like to begin, please introduce yourself for the record and present your testimony.
Thank you. My name is Jillian Christensen, and I live in North Creek, a mobile home community in Lakeville, and I'm here today in support of Bill 4909. Have any of you ever been through an eviction process? I've been through 6 of them with residents from my community. The shame, the embarrassment, the fear, and feeling powerless against these big corporate lawyers is the worst feeling. But when you are ordered by the judge to move out of your home that you own in 7 days, or you'll be arrested for trespassing, is even worse. And that is our current state law. If you are evicted, you have 7 days to pack up your entire home, find somewhere to go, move your home off the lot, if that's even possible. It costs $25,000 to $35,000 to move a home, then find a place to move your home to, or try and sell it. If you can't move it or sell it, the park takes it. While all this is happening, you still have to go to work, get your kids off to school, help them with homework, and try your best to assure them that everything will be okay, while holding back your tears knowing things will not be okay. That is what happened to a resident who moved into his home in 1989. Last September, he was brought to eviction court. The judge said he had 7 days to move. I helped him pack up what we could in 7 days, hugged him, and waved as he drove away. As of today, he's still living in his car. The shelters are full, the county is out of funds to help him, and with an eviction on his record now, no one will rent to him. Residents in mobile home communities are in a crisis and need help. This bill is one way out of many that will start to make sure manufactured home residents are treated with dignity. Re-residents need a fighting chance. Just imagine if this happened to you. Would 7 days be long enough for you to pack up your entire life and move it when you have nowhere to move it to? In my park, we have organized and built people power and collected signatures to form our resident association, and we have knocked on 10,000 doors in 36 other communities and have heard the same story. And now I'm here knocking on your door, asking you to do something. You all represent Minnesota and are supposed to protect Minnesota residents as best as you can. Today, I'm asking you to be at your best and vote yes for this bill. Thank you.
Thank you very much for your testimony. Ms. Lambert, please introduce yourself and proceed.
Thank you. Good afternoon, Chair Bolden, committee members, and committee staff. My name is Erin Lambert. I was born and raised in Minnesota. I am both a local manufactured home community owner, not private equity, and an attorney representing over 13 communities across the state. Through my work, I have extensive experience with Minnesota Statute 327C, which governs manufactured housing, and how these laws function in both practice and in the court. I am here today in opposition to Senate File 4909 because it raises serious constitutional concerns. First, this bill eliminates judicial discretion. Beginning on line 1.8, The bill mandates that a writ of recovery must be stayed for 90 days. And on line 1.12, the bill requires post-writ occupancy for 10 days. Under current law, the way the statute is written, judges have the ability and discretion to issue up to a 7-day stay for a writ of recovery and issue up to a 60-day conditional writ, which means if the resident continues to pay and maintain the property, they can continue to keep their home in the community. This judicial flexibility is critical. It allows judges to determine different outcomes in cases involving safety concerns, including criminal behavior, while in other cases, still providing that additional time to those who need it. This bill replaces that crucial judicial decision-making with a rigid one-size-fits-all mandate that applies in every case, regardless of the underlying facts. This is especially concerning in those cases involving residents who have engaged in harassment, threats, or violence against other residents or other property managers. Under the bill, communities are required to allow the individuals to remain in the community for 10 days and continue assessing the property for up to accessing the property for up to 90 days, even if they impose an immediate harm or threat to the community. This raises serious public safety concerns. Second, this bill harms not only communities, but residents as well. By requiring a mandatory 90-day stay without rent payment or home maintenance, the bill removes critical accountability measures. Under current law, any additional time given to residents over 7 days is conditioned on compliance of community rules, as well as continued payment of rent to ensure properties remain safe and livable. This bill eliminates those safeguards. There is no requirement that an evicted resident maintain property or refrain from damaging community property during the 90-day period. In effect, this allows the condition of the property to deteriorate unchecked. As a result, communities must absorb months of unpaid occupancy while managing deteriorating home sites, code violations from municipalities, and safety risks as properties go unmaintained and neglected for extended periods. This does not just impact owners. It directly affects neighboring residents who would be forced to live next to these unsafe or unmaintained properties, unless community owners front the bill and maintain the lots themselves without compensation. In practical terms, the bill requires community owners to allow continued use of their private property by individuals who no longer have any contractual right to remain, placing a public burden on a private property owner without any corresponding compensation or recourse. Third, beginning on line 2.8, the bill requires that if a community owner acquires title, the owner must later return sale proceeds to the resident. This provision undermines the purpose of a title transfer and interferes with the ability of owners and residents to freely contract. In practice, the manufactured homes being transferred to the community are typically from the 1970s or earlier, were not meant to last as long as they do, have little to no value, and are acquired by the community because the resident was unable to sell them on the market. The community owners accept or purchase these titles to mitigate their losses and residents' losses, resolve the residents' unpaid rent, and restore the home site for future occupancy. Residents in turn may voluntarily relinquish title in exchange for rent forgiveness and to avoid additional costs such as brokerage fees, removal fees, and sales expenses. This bill disrupts that arrangement by requiring owners to return sales proceeds and freely become the resident's broker, eliminating the incentive to take title or invest in repairs and resale, particularly where key terms such as actual costs are undefined, ambiguous, and likely to create disputes. The result will be that there are fewer voluntary title transfers, more abandoned homes that will be demolished, less affordable homes on the market, and increased resident debt. These costs do not disappear. They are shifted into higher operational costs, which ultimately lead to higher rents for other residents. In closing, this bill does not create balance, it removes it. It removes judicial discretion, it removes accountability, and it removes practical pathways for residents and owners to freely contract. In its place, it creates rigid mandates that increase risk, reduce flexibility, and ultimately harm the very communities it is trying to protect. For those reasons, I respectfully urge the committee to oppose Senate File 4909. Thank you for your time and consideration.
Thank you for your testimony. Senator Abeler.
Are there any more testifiers?
No.
You can stay if you want. Well, I appreciate the discussion. I just see it as a real power imbalance, Madam Chair. And Ms. Lambert is eloquent, and I think the bill needs some work. but so does the industry. So does this topic. The answer to this topic should not be a blank piece of paper, which is what it has been over and over. And I think actually owners of the caliber of Ms. Lambert are the very ones to help sort this out, to create some of the rights that are challenging. I think the wrong ones to talk to are the ones that are paying twice the value of a piece of property, so they can. The slogan was that they're like having, customers chained to a booth at Waffle House. And I find that, when I heard that, that was greatly offensive, and it was a real sentence. And I don't think that Ms. Lambert or the people, the owners like her, see their residents anything like that. And so, but I think the balance of testimony here, where you have a week and then you're gone and you have nowhere to go, compared to, 90 days, it's a number. I don't care what the number is, but I think there needs to be a little more due process to have a chance. And if it's a tacky old, if it's an old property run down and, not very good anyway, then, somebody has to haul it away, and it's, that's lucky they can, but it's still their home, but some of these homes are really nice, and the same criteria is for that. I visited a place, and this guy had spent $180,000 to buy a mobile home, to risk having the rent go up more and more, and the risk to losing all that equity and the mortgage he's got and now his credit, if he should happen to not be able to make the payments. And so there needs to be something in between. It's not just a car, even though it's a mobile, manufactured home. So I hope that there's somewhere that can go with this. And anyway, that's my thought there. And it's such a perverse incentive. And we had a good chat. Thank you. But it's a perverse incentive. If you remember the property tax liens, where people lose their home for property tax, and then the counties were keeping the home and the money, and that was the thing. This is the same thing, only it's a much smaller project, but it's their home. And at a time we're trying to keep people housed instead of unhoused, trying to help people in their time of distress is really important. And distress is all relative, and so if your rent is $800 and it used to be $400, and you're having a hard time making it, and you fall behind, you have some medical bill, and suddenly your life has collapsed. So 3 months, and you have 7 days, or the little delay in the court time. Okay, maybe you have 4 months and a little longer. To have your life just collapse all the way around you, it seems unfair, and I don't want to unduly burden, particularly the thoughtful, regular people that are homeowning. I don't mind a bit, frankly, that the people that have taken this on as a major profit venture, that they should have a little ding in their profits. And I'm not a socialist, but there's a fairness, and I think there's a responsibility that a park owner, that I think Ms. Lambert shares, a responsibility for the welfare of their people, and I heard that in her comments. And so I think there's somewhere to go with this, and I hope there's somewhere to go even this year in a way that does more than just create another working group to talk about it, but to actually get some relief. And so you can reply to that if you want, or let me keep going. You want to comment?
I can make a little comment.
Ms. Lambert?
Thank you. I would just like to say your efforts are working in regards to manufactured housing. Since I became an attorney in 2023, which I know is not that long, 99% of our cases that do reach eviction courts are settled due to the finances that are now available to residents. They don't just go out on the streets. They go back into their homes. They work out a payment plan where the counties are able to help pay their rents. So your efforts are working, and I believe the removal costs might be a way for a grant, or for grants. Right now, they do get those 60 days to be able to remove their homes if they would like to. So I think if you would like to continue discussions, that would be great.
When I think
Senator
so,
Abeler.
And so if you look at the attitude of this fine homeowner here compared to what we've sensed on some of the rest, and everybody insists they're a great park owner. Oh, we're private equity, but we're the good one, And people surely don't mind paying $1,000 for this nice new kiosk we built, and and we plowed the snow real nice for them. And but it's just I'm just really sad about it. I'm happy to be part of what we're trying to get after. And so eventually at the end, the motion would be to send it, I think, without recommendation to judiciary, implying it needs some work and it'll rest there. And if we can't figure something out, then that may be the end of it. But I'm still going to continue to work to find something that's not judiciary rated for that, for next week. So, Anyway, so, and now there's more questions, looks like, Madam Chair.
There is. I'm first going to go to Senator Draheim.
I think, thank you, Chair.
Senator Draheim, you are cutting in and out.
Is that 14-year-old to help them out? So you live at the park, or do you-
I'm good, thank you.
Okay, all right, very good. Senator Palm.
Thank you, Chair. I want to say thank you to Senator Abeler for bringing this bill forward. Manufactured homeowners need protections. They're in a unique situation that has unique challenges. The fact that people cannot get their surplus proceeds after the sale of their home is ridiculous. That is something that should be happening. Homeowners who lose their home and after the home park has sold it, in the surplus after expenses should be returned to those homeowners. And I like that this bill does that. The other thing that I really think is important to note, as one of the testifiers spoke about, is the cost to move one of these units, manufactured home, out of that park. It is not easy to move. And to say 7 days is long enough, that is not long enough. And so I appreciate Senator Abeler bringing this bill that extends that time, because they are in a unique situation, and people will need more than 7 days. So thank you, Senator Abeler. You have my support on this bill, and I hope that we can move this forward. Thank you.
And Madam Chair,
Senator Abeler.
just one thing, I got distracted in my own comments. So the perverse incentive, which I'm not sure how you fix it. So if you give the people the money, then if it's kind of marginal, they just might tear it apart. Like, and that's the part that makes my head want to explode. But anyway, it's working with thoughtful owners. We're not trying to put them out of business. I don't want to cost them their livelihood either, but there's two livelihoods here. So anyway, just thank you, Madam Chair.
Senator Grunhagen.
Oh, thank you, Madam Chair. Yeah, I have empathy for people losing their houses, okay? And I don't want to see that either. On the other hand, when I look at government here in Minnesota, it seems like so much of what we do actually cost shifts or makes the situation worse. And what I mean by that is, you know, Ms. Lambert did testimony too about cost shifting to other people in the where the other manufactured homes are. And, you know, it just seems like this bill needs a lot of work, in my opinion. And I think you need to come to some peace in the valley between Ms. Lambert, or Mrs. Lambert, and I assume you're married, you got a wedding ring on, so.
Engaged.
And that bill. I do appreciate that you would have the bill move without recommendation, because you know, when you're trying to solve one problem, there's a ripple effect that hurts other people that can push them into the same situation that you're trying to solve. And that's the way I see this bill. You know, there are some good parts here, but again, I think one of the problems is the increasing cost of operation for these owners. And that is driving a lot of this increased cost. Again, I would just reference the cost of building a residential house in Minnesota compared to South Dakota. It's almost $200,000 cheaper to build the same house in South Dakota than it is in Minnesota, according to this analysis. And according to the U.S. median average for the same house all across the United States, you're at about $150,000 to $160,000 cheaper in other states on average than you are in Minnesota. And here we have people we want to help, you know, people who are losing, have worked and paid and tried to own their manufactured home. And I have empathy for that. you know, I want to help them too. But on the other hand, government sometimes comes with provisions that make things worse for other people and actually don't help the situation, but drive up the cost and discourage the owners from solving the problem. And you said if I understood you correctly, Mrs. Lambert, 99% of the situations of eviction get resolved. Did I hear that correctly?
Ms. Lambert?
And I don't know if that's for everybody, but for our community, or for the communities that I handle specifically, we come up with settlement agreements. And I know a lot of landlord-tenant attorneys across the state have also gone more towards settlement procedures in the last few years because the state has given so much money to tenant-landlord issues.
Senator Gruenhagen?
Oh, thank you, Madam Chair. So you know, I think there needs to be a lot of peace in the valley and compromise on this bill. I think there are some good parts, as Senator, is it Pugh or pointed out, but I think there's a lot of things in here that are simply going to drive up the cost and cause cost shifting to other manufactured home owners and actually aggravate the situation worse than what it is. And again, Minnesota has a habit of doing this, of driving up cost and actually making things worse based on good intentions. And I see a lot of good intentions in this bill, and I'm empathetic to it, that we need to be accommodating and compromising where possible. But I think in the long run, it's going to do more harm than good, to tell you the truth. That's my initial read. So anyway, thank you, Madam Chair.
Senator Abeler, any follow-up comments?
Closing comments when you're ready.
Any, Senator Clark?
Thank you, Chair. Thank you, Senator Abeler. I think I'll highlight two things in here, and it's an attempt to correct the power imbalance that you mentioned, and that is crucial in all this. And I don't know that we'll ever get to peace in the valley on that, but it's a worthwhile conversation to have of how do we make sure that we can keep these folks in their home. And I think that's what everybody has the intention to do here, and as you've said, and appreciate the work that you've been doing to keep your residents in homes. But this is a place where we can help with this naturally occurring lower cost home ownership thing that my parents took advantage of when I was born living in a mobile home, a manufactured home, that we can do. So I think we keep working on this. I think Senator Gruenhagen may have some ideas there's pieces in here, Senator Gruenhagen, that you do and will like. So please, I'm glad to be on the bill. Let's keep working on this because let's get there.
I will move to you, Senator Abeler. I will just add my thanks to you for working on this bill, on this issue, as I have also been working with folks on an issue related to manufactured park homes. The power imbalance is stark, and adding some fairness back into a system that where it isn't, I think, is important. And there certainly are owners who are reasonable and want the best for their residents and are doing things in a fair and right way, but there are many other owners who are absolutely not. And so we should have protections in the law in place for those residents to avoid situations like that we heard today, where people are losing their homes and moving to then live in their car. Like, that is unacceptable. And so this is a step in that direction, and happy to work with you as it moves forward. It's important and work that we should continue. As I move to you for closing comments, I will also just maybe let you point us to what you would like where you would like this bill to go. It is set to go to the Judiciary Committee. And I guess I would ask, do you want to go there with a recommendation to pass, without a recommendation? Open to hear what your wishes are. So Senator Abeler.
Well, I'm glad I can move there in some form. I think the fair motion is without recommendation. This is the first hearing of this bill. I did actually press the advocates. I said, don't you have something about this equity thing? They said, yeah, we're going to do it next year. It's like, let's do it this year. Let's get the conversation started. I think this is healthy. And I think that if it could move without recommendation, that would be respectful to the testimony of Ms. Lambert and the other people with concerns, but also reflective that it needs a bunch of work. Just one thing else, I don't know, it'd be interesting to see what we can rescue in time for next week that's not a judiciary thing, we can get, at least bring it in closer to home for timelines or whatever. We'll just see what we get. And then people can vote on it whichever way it decides to go. But we'll also be talking to Ms. Lambert about that, and it'll be in better shape than you see it today. But also, I think if it's relevant, we do also want to not provide for people that are public safety risks to be allowed to stay if they're actually some kind of like that angle, which is, I think, a very clear gap in the bill about who gets to stay. And so that could be probably defined somehow. If that element is relevant to what we're going to try to pass. So I'll talk to staff about that. So in good faith, Madam Chair, lots of good things can happen. And I really appreciate the dialogue we've had today with this good faith owner here and the staff. And I'm glad he sees merit in it. And, you know, so I think we're on a good path on a very hard topic. So thank you, Madam Chair.
Thank you. I'm going to make a motion, but I will just note, because it is a late bill, it will automatically go to the Rules Committee. But Senator Abeler moves that Senate File 4909, without recommendation, be re-referred to the Committee on Judiciary and Public Safety. All those in favor say aye. Aye. All those opposed say nay. Motion passes, and the bill is on its way to Judiciary.
Thank you, Madam Chair and members.
We'll next move to Senator Paz, Senate File 1671. Senator Paz, to your bill.
Thank you, Chair Bolden and committee members, for this opportunity to have an informational hearing on SF 1671, Right to Renew. I do want to just thank Senator Clark, Senator Mohammed, and Senator Port for also being co-authors on this bill with me. Chair Bolden, I do have an author's DE amendment, the A4, I'd like to bring forward to adopt.
Yes, Senator Paz, you have the A4 amendment, which is an author's amendment, I believe.
Yep.
Very good.
Yes. And it
Members,
is a DE, so we will walk through the subdivisions. in a
very
little
good.
bit.
Senator Paz.
Thank you. Do we need to adopt it before I go, or
We can adopt it.
can we do it after?
Yeah, we can adopt the amendment. Senator Paz moves the A4 amendment. All those in favor say aye. Aye. All those opposed say nay. Amendment is adopted. Senator Paz.
Thank you, Chair Bolden. Right to Renew addresses a gap in current law. Today, landlords are required to notify tenants when they're ending a lease, but they're not required to say why. That leaves renters in the dark, and it leaves the door open for unlawful evictions, including retaliation and discrimination. And here's why it matters. A family in Minnesota can do everything right. They can pay their rent on time, they can take care of their unit, they could be a good neighbor, and they can still lose their home without a single word of explanation. No reason given, no recourse, just a notice to leave or that their lease will not be renewed. And when that happens, the cost is real. A displaced family faces moving expenses. They have to take time off of work. We're talking about thousands of dollars when 1 out of every 3 Minnesota households right now cannot afford basic necessities. This unexpected expense families have to incur, they cannot afford. And it's not just financial. Many times kids have to change schools mid-year. That's a disruption for our children as well. Established connections to their communities, their support networks are also disrupted. And again, this also impacts college students too. I know we've had a lot of conversations about college students and housing for them as well. This bill simply says if you're not renewing someone's lease, you need to give a reason, valid reason for why tenants' leases are not being renewed or being terminated. And those reasons are there's a lot of valid reasons that you can use. So if it doesn't fall on some of these valid reasons, then oftentimes it can be reasons that are discriminatory. And those valid reasons are non-payment of rent, repeat late payments of rent, It could be anything that's a material breach of their contract, which is property damage, and many things under that category. Tenants can choose not to renew the lease. Occupancy by landlords or landlords' family members is a reason to not renew. Withdraw from the market because of demolition or a dwelling conversion, and also for the sale of single-family homes. Rehabilitation and renovation, complying with government order to vacate, occupancy conditioned on employment. These are all valid reasons that people can put down as a reason for non-renewal or for termination of a lease. And so this bill gives tenants the basic fairness and transparency they deserve and strengthens the stability that makes our communities and our rental market work for everyone. Chair, I do have a few testifiers. I'll leave that to you.
Thank you, Senator Powell. We do have a number of testifiers. I will ask people to try to keep your testimony to a couple of minutes so we can get through everyone. First, we will hear from Cecil Smith, and I will also invite to come forward Jessica Zuminski. Mr. Smith, please introduce yourself for the record and begin.
Thank you, Madam Chair. Members of the committee, my name is Cecil Smith. I'm the President and CEO of the Minnesota Multi-Housing Association. MHA is an industry nonprofit representing 2,300 members and over 300,000 rental units, which are home for over 600,000 Minnesotans. I'm here today to respectfully raise MHA's opposition to Senate File 1671 as amended. Housing providers share the goal of stability in housing, and we appreciate the effort to outline specific grounds for lease termination. However, we are concerned that a just cause requirement could unintentionally limit a provider's ability to respond to situations that impact the safety of other residents and on-site staff. Property owners and managers have a responsibility not only to an individual resident, but to everyone living and working in a community. There are times when significant antisocial behavior may not neatly fit within the listed categories, yet still create serious concerns for neighbors and staff, such as repetitive, disruptive, or threatening conduct. This can include racial epithets, religious slurs, or sexualized remarks or gestures. In those situations, providers need flexibility to act, including non-renewal of the lease. Restricting termination only to defined categories may delay appropriate action and place other residents at risk. As employers, housing providers also have a duty under the law to maintain a safe workplace. Managers, maintenance techs, and other employees interact with residents every day. If the ability to end a tenancy is limited, providers may be forced to continue managing situations that create unsafe or hostile work conditions for employees, which creates conflicted policies. Housing providers must balance individual tenancy rights with a broader obligation to ensure safe and stable communities. This proposal makes it more difficult to address involving safety concerns and could unintentionally affect the well-being of other residents who also have a right to a quiet enjoyment and safe housing. Non-renewal of an existing lease is a serious expense and a significant financial disincentive. But current law allows providers to act appropriately when safety concerns arise. Thank you for your time.
Thank you for your testimony. Next, Jessica Zuminski. After that will be Saritha Lee.
Thank you. Thank you, Chair Bolden, members of the committee and staff. My name is Jessica Shiminski, and I'm an attorney from the Housing Justice Center. HJC is a nonprofit public advocacy and legal organization dedicated to preserving and expanding affordable housing for low-income individuals and families and improving the housing system for all Minnesotans. I'm speaking today in strong support of Senate File 1671, establishing the right to renew. This protection is necessary for a myriad of reasons. To start, the relationship between landlord and tenant is inherently unequal, with the landlord exerting unparalleled influence over the rental relationship, with leases these days regularly exceeding 30 or 40 pages of landlord-friendly terms. Senate File 1761 provides an answer to this imbalance, protecting the rental consumers who do not have their own seat at the landlord-tenant negotiation table. Quite simply, housing is a human right, and Senate File 1671 is just one step towards rebalancing the dramatic disadvantages renters face in our state. Senate File 1671 is a housing stability and cost-saving measure that prevents homelessness and displacement. It also protects against both retaliation and discrimination. Even though these are both illegal under Minnesota law, there are landlords who use their power to non-renew to get rid of tenants for dubious reasons. Under Minnesota law, landlords do not need to provide a reason for non-renewals. Non-renewals can be used as a tool to remove tenants who exercise their rights, such as those who request reasonable repairs, contact city inspectors, and those who help organize their neighbors to create a tenant union under the right to organize. Some tenants are scared to enforce their legal rights for fear of being seen as a difficult tenant who won't be issued a lease renewal when the year is up. This is common, and I have seen this happen in my practice. For example, in 2024, I worked with a young mother who received a non-renewal notice right after her baby was born and after she had made multiple requests for needed repairs. The message couldn't be clearer. Be quiet, pay your rent, and don't ask for anything if you want to stay beyond your lease term. The right to renew is not new to Minnesota. It already exists in manufactured housing, in low-income housing tax credit housing, and in rental housing in Brooklyn Center. At the HJC, we've seen the right to renew in action to prevent the needless displacement of tenants. In Brooklyn Center, Housing Justice Center brought a class action lawsuit on behalf of a group of tenants who had been racially discriminated against by their landlord. Once the lawsuit had concluded, the landlord began issuing non-renewal notices with no cause provided to those who had been protected by the litigation. HJC was able to intervene and help the tenants assert their housing rights to prevent the baseless displacement of over a dozen households. In contrast, a disabled tenant I represented in St. Paul was non-renew after our lawsuit settled. Because St. Paul does not have the right to renew, we were unable to protect our former client from displacement. Due to her disabilities, finding a new place to live that met her needs was nearly impossible. The right to renew does not stop landlords from protecting their properties. Some landlords oppose right to renew because they would rather non-renew a tenant than take them to eviction court. However, any of the legal reasons that a landlord would want to evict a tenant for are covered by the acceptable grounds for non-renewal under Senate File 1671. Nothing in this bill prevents a landlord from moving tenants for non-payment of rent under Minnesota Statute Section 504B.291 or breach of lease under 504B.171 or 504B.285. Which are the most common lawful reasons a landlord may seek to repossess their property. This bill carefully strikes a balance between the needs of property owners while increasing the long-term stability of renters. Having these grounds established protects tenants against non-renewals for retaliatory or discriminatory reasons. The right to renew protects tenants from arbitrary and unjust non-renewals and prevents the needless displacement of Minnesotans from their beloved homes. Minnesotans deserve the opportunity to establish themselves in their desired neighborhoods and build community. Minnesotans deserve stability and the comfort from knowing that they won't be displaced from their housing when their lease comes up for renewal. Minnesotans deserve clarity, consistency, and fairness. Minnesotans deserve the right to renew. Thank you for your time and consideration.
Thank you for your testimony. Next is Saritha Lee, and after that, Wajan Kim. Welcome to the committee. Please introduce yourself and begin.
Good afternoon. My name is Saritha Lee. I am a mother, a community leader, a community organizer, and I also serve on the board and as a housing commissioner in Brooklyn Center City. In 2022, Brooklyn Center successfully adopted the Just Cause Right to Renew policy that is now being considered at the state level, demonstrating that the policy is both practical and effective. I am here today because I know what it feels like to almost lose your home. In my building alone, over 40 families were given non-renewal notices. 40 families were at risk of losing their homes at the same time. Families who were paying their rent on time, raising their children, and were suddenly faced with displacement. If those non-renewals would have gone through, the families in my building would have had nowhere to go, loss of their jobs, children would have been displaced, families may be homeless, our communities would have been torn apart. I want to be very personal with you. If it wasn't for Just Cause Renewal, my family and I would not be in our home today. Just Cause gave us a voice, it gave us time, it gave us the right to defend ourselves, and not be pushed out without a real reason. Because of Just Cause, many of my family members and neighbors are still in their homes today. Policies like Just Cause rights to renew exist because housing stability, housing health, and housing community. I am asking you to support Just Cause rights to renew statewide so that what happened to those 40 families in my building does not happen to other families across Minnesota. Everyone deserves fairness. Everyone deserves stability. Everyone deserves a place to call home. Thank you for listening.
Thank you for your testimony. Next, we will hear from Wajan Kim. After that, Leah Merritt. Welcome to the committee. Please introduce yourself and begin.
Yeah, thank you, Chair, and thank you, Senator Fott. My name is Hwa-Jung Kim. I use she, her pronouns. I have the pleasure of representing Ward 5 on the St. Paul City Council. I'm testifying today in support of Senate File 1671. Nearly half of St. Paul households are renters, and that's census data. And as a municipality, then we have a direct invested interest in stabilizing communities in our city and protecting them, most importantly, from displacement. My ward also includes the North End and the East Side, where we find many of our migrant families establishing themselves, housing themselves, and most importantly, opening businesses. I've heard loud and clear over the last several months from renters just how precarious their housing stability has been, especially with Operation Metro Surge. This bill creates a consistent process for all Minnesota tenants who will be able to expect the same process regardless of where they choose to rent. Right to renew is not new or untested. Public housing, federally subsidized housing, low-income housing tax credit properties, they already fall under Just Cause standards. Minnesota's own mobile home park statutes already requires cause for eviction. And as we've heard from before, multiple states like Oregon, California, Washington, Colorado, New York, they've all enacted similar protections. Landlords can still evict their tenants and not renew for non-payment, but this doesn't impact lawful evictions. It just requires them to identify the reason for the non-renewal. And I believe strongly that knowing the reason for non-renewal will only make them better tenants in the future. Housing is not just a commodity, it's a necessity. And for the second time in this decade, the fragility of our renters and the housing environment were put to the test through this pandemic and the Operation Metro Surge. This bill is a necessary need. It's a necessity for renters who need strong protections and legal tools to ensure they can keep their families housed. And I strongly, strongly encourage members to support the bill. Thank you for the time, Chair.
Thank you for your testimony. Leah Merritt, and lastly, Angela Bonfiglio. Welcome to the committee. Please introduce yourself and proceed.
Good afternoon, Madam Chair and committee members. My name is Leah Merritt, and I'm a policy fellow at the Council for Minnesotans of African Heritage, CEMA, the state's advisory body for African American and African immigrant constituents. Thank you for the opportunity to testify in support of Senate File 1671. Under current Minnesota law, landlords may terminate leases without providing a reason. This practice leaves many renters vulnerable to sudden displacement and contributes to housing instability that disproportionately affects communities of colors, immigrants, and refugees. Research shows that abrupt terminations can destabilize families, disrupt employment, and increase the risk of homelessness. This legislation establishes clear and reasonable standards for when a landlord may evict a tenant or choose not to renew a lease. These protections are especially important for African heritage communities who rely on rental housing and face heightened vulnerabilities when leases are ended without cause. By requiring documented reasons, this policy promotes fairness and accountability that's essential for community well-being. CEMA believes that housing policy must advance stability and equity for all Minnesotans. We thank Senator Pa and Representative Agbaje for their leadership and urge the committee to pass Senate File 1671. Thank you.
Thank you for your testimony, and welcome to the committee. Please begin, introduce yourself and begin.
Hello, members of the committee. My name is Angela Bonfiglio. I'm a community organizer and state policy lead for Neighbors for More Neighbors. We are here to support the passage of the Right to Renew Act. You often see our organization here to speak on building more homes across the state, but we know that building more homes is not enough. We know renters deserve to stay in the communities that they choose, and that's why we need renter protections like the right to renew. I'm going to share a personal story with you on why Right to Renew is so critical. I lived 8 years in the Harrison neighborhood in North Minneapolis, 2 years renting in a home and wanted to stay in the community, and lived 6 years in an apartment building. I lived alongside renters who had built long-standing relationships with each other and with the community. We were serving on neighborhood boards, we were volunteering in after-school programs, we were helping clear each other's car during the Minnesota winters, and looking out for each other during the pandemic. These are all things that don't always come easy in communities, but lend themselves to a thriving and safe community and home. After changing management from our nonprofit landlord, we faced a lack of repairs, lack of communication, and threats from management. As we spoke up about our concerns with reasonable repairs, we faced threats of displacement, including their attempts to end my lease during the eviction moratorium in 2021, in January. Not for non-payment of rent, but for speaking up with my neighbors about my rights as a renter. Then again, 2 days after the eviction moratorium was up in October of 2021, me and many of my neighbors who had lived in our building and invested in our neighborhood between 4 and 15 years were displaced by a non-renewal of our lease. Others in our building also started to find housing elsewhere because of the threats of the displacement. And within 3 months, almost all of my neighbors had moved out. Many of us wanted to stay long-term in the neighborhood, and instead of having the opportunity to do that, we were suddenly uprooted from a community that we loved and cared for in the middle of a pandemic. We were not given a reason or time to make adequate move to continue to stay rooted in our neighborhood, and Right to Renew would have provided that. I get emotional listening to Ms. Sarita's testimony because I know in my lifetime this type of community will be nearly impossible to recreate. People want the opportunity to make their house a home, and having Right to Renew will clearly give understanding to both renters and landlords when those agreements shift and why, so that renters can invest and be stable where we live. Thank you for your time.
Thank you for your testimony. Senator Pott, any other comments before we move to discussion?
Nope, nothing else. Thank you, Chair Bolden.
All right, members, questions or comments? Senator Gruenhagen.
Oh, thank you, Madam Chair. Yeah, I'm going to be bipartisan in my concerns, I think. Doesn't matter whether you're Republican or Democrat. You know, I did find, I'm empathetic to the situations that were shared, but I did find Mr. Smith's comments and concerns quite reasonable. And what I mean by that is, members, first, I'm not a cold, harsh person, okay? Just to let you know, I did jail ministry for 13 years, never got paid, just caring about people. Write checks out to people who try to help them out financially when they need it. We got a canning company in my community, so we got a lot of legal illegals come in, and I don't care. I just write a check out and help them get a room for a night or whatever it takes. So I am empathetic. But, 9 times out of 10, when you have a bill like this, or the previous one, that starts micromanaging what a landlord can and can't do, what happens is you discourage people from becoming landlords. And the first meeting we had here in housing, you know what we heard? Shortages of rental property, shortages of housing, and when those shortages happen through more and more government regulations, it discourages landlords and people of means to actually provide the housing. The result is that when you create those shortages, the price of everything goes up. That's what happens. And then you have the ripple effect of destroying people's lives in many cases. So government good intentions, 9 times out of 10, when they start getting micromanaging the situation, which I see this bill taking us in, and makes things worse rather than better in most cases. So I understand why you're trying to address it. I think the bill needs a lot more work, especially with the concerns raised by Mr. Smith. And the last thing I want to do when we already have shortages and we're already artificially inflating the price of everything in this state through government mandates, taxes, and regulations, is to throw more more regulations on top of what's already discouraging. So, and I wish I could resolve every possible issue out there, but government makes things worse in many cases, and I could go on, you know that, but printing up money, inflation, and who's the cause of that is stupid government economic policies. So I want to help people in problems, difficulties too, and I have. I spent a lot of my life trying to help people, but not to the point of creating more shortages, which I think, unfortunately, this bill and the previous bill is going to take us down that road. So, thank you, Madam Chair.
Senator Pa.
Thank you, Chair. Senator Gruenhagen, thank you. And we do see that there are some work that we have to do with this bill. We continue to do that work. In the end, what we want is a bill that gives, that's transparent, that also gives accountability and protects people from discrimination and unlawful eviction or non-renewal of leases. And so, Senator, I'm more than happy to work with you and also with the Minnesota Multi-Housing Association further on this bill. In the end, we want to make sure that we protect families. Thank you.
Senator Abeler.
Well, thank you. And I think there's a tone we have today. It's like, let's try to figure out how to make this work in the environment we're in and give some relief. I like the bill in general. I listened to some of the safety thing that's easy to conjure up something about that if they're a public safety threat or something. In both the last two bills, that was a big concern, and I don't think anybody wants anybody living there if they're dangerous neighbors, for heaven's sakes. So I just have a question. I don't even know how to ask it really, but some people just aren't good neighbors. I mean, they're just, is that enough to leave it at that? And that the owner would just say, there's just all these little small problems all the time, and I would exercise my right not for being racist or anything. We just aren't getting along, and the neighbors aren't getting along, and so I mean I don't even know how to. And that's the right they have now. I used to have property, and so we didn't kick anybody out. But is there? I mean, I think that would probably help some of the owners just to have as you negotiate, just to think. I mean, there's some people they're not tidy, they're loud, they're not breaking the law, but they're just, I don't know, just, I mean, it's not that the car is parked crooked. I mean, the same thing where it's over time the people would agree to, vote them off the island or something. So is there somewhere to go with any of that? Is that a goofy question?
Senator Pa.
Thank you, Chair Bolden. Senator Abeler, thank you for your question. I would say this, there's two parts. I think you talked about some things that don't necessarily fit into some of these categories, but do actually fit into the material breach. And so that material breach really covers quite a bit of things. So like say, for an example, in your lease, it says you can't have it can't be loud where it distracts or it disturbs other people from their use of being in that same building. So if you have an enormous amount of sound and it's constant and it is now disturbing other people's peace, that is something that fits under material breach. If you now turn your single-family home, a backyard, into a junkyard, and that's something that's not allowed, that falls under there. If you cause damage to the property, a broken window, you refuse to fix it, you start punching the walls and you don't fix those damages, those types of things. There's a lot of things that fall under the material breach. That's why that is there, to fit all those other categories. What we want to prevent is kind of something you touch a little bit on, which is that I'm a great tenant. Maybe people don't like me. I'm not a very personable person. I'm a great tenant, though. I pay my rent. I don't bother anybody else. I do my thing, but the property management or the landlord just doesn't like me. They decide they don't want to renew my lease, or they want to, and that's, but people have to understand, that's my home. Like, I live there, that's my family's home. We've set our lives in that neighborhood. And it does bother me to say, just because you don't like a person means you can now non-renew their lease, even though they're perfectly great with paying their bills and everything else. It doesn't bother anybody else. I really wish that property management and landlords, I'm not saying all, but some don't understand that when they don't renew someone's lease, they're going to displace them from a community in which they are already a part of, that they may have support systems in, that they may be close to their workplace, that their children are going to that school, and now they're going to have to go to a different school. Like, there's so many impacts when you aren't allowed to renew your lease. And if it's for valid reasons, yes, that's covered. But if it's because my property management just doesn't like me, that shouldn't be a reason.
Madam Chair.
Senator Abeler.
No, that's a really good answer. And so I support your work, and I hope we can get, again, I hope we can move something this year. And, you know, if all the landlords were like some of the ones that we know, you wouldn't even need this. And I'm just, again, back to the power differential, and not to be, you know, like too much power, but there needs to be at least something equal-handed where, especially as we get more and more remote owners, and they never even have any idea what they're doing, and it's, anyway, so good luck with it. Happy to be a part of helping if I can be. Thank you.
Thank you.
Senator Clark.
Thank you, Chair, and thank you, Senator for your work on this. In your research on this, I think one of the things Senator Gruenhagen shared was that this will, you know, drive up the price or reduce supply. Are you aware of any studies or work that's been done in looking at states that have already implemented this type of work to see how it affects supply or price? Is this, you know, we've already got in the marketplace of ideas, this in 7, 8, 9 states. Have they had any outcomes that you're able to share?
Senator Pa?
Thank you, Chair, and thank you, Senator Clark, for your question. I actually have an answer for you, but I think that Jessica will be much better at answering this than I do. So I'm going to turn it over to her.
Ms. Szyminski.
Thank you, Chair, and Senator Clark. So the University of Minnesota Cures program actually did research to show that in other states, which included California, Oregon, New Jersey, and Washington, that passing just cause policies did not see a decline in housing production. And so when the concern is that, like, this policy will raise prices by decreasing production and the availability of properties, and that just wasn't the case of what the research demonstrated. And if you had another study to add, I would love to pass it back to you.
That's good.
Okay.
Senator Pa? No,
That's good.
Senator
Thank
Clark.
Thank you, Chair, and thank you, Senator Pa, and thank you. I think that's the key point, that this provides stability while maintaining supply. We've been doing a lot of other work to ensure that we continue to expand supply, and what I'm hearing you say is this is something that doesn't negatively affect supply. In fact, it's something that will be a net positive. So thank you.
All right, appreciate the discussion. Thank you, Senator Pa, for your work on this. I'm going to turn it to you for closing comments. The path for this bill is to go to the Judiciary Committee. Is that your desired path for this bill, Senator Pa?
Thank you, Chair Bolden. Yes, please.
Very good. So any closing comments before we make
Chair.
that motion? Senator Abeler.
Just understanding timing and everything, is there a part of this that we could rescue that doesn't have to go to judiciary, or is it all just such a contractual thing that there's no way to weasel out of that? Is there something?
That is an excellent question, but it falls under 504B, which is under the jurisdiction of the Judiciary Committee. So there really is not a way to pull pieces out. It all has to go to the Judiciary Committee.
Could we create a chapter like 104, housing policy, right to renew stuff? Never mind, thank you.
Good question. Senator Pa, closing comments before we make a motion.
Yes. Thank you, Chair Bolden, and thank you, members, especially my co-authors who are also on here, Senator Mohammed, Senator Clark, and Senator Port, for your support on this bill. I'm hoping that we will continue to work together on this bill as it moves to the different committees, and I'm more than open to working with the different stakeholders and different senators to improve this bill as we move through. But I look forward to your support because honestly, Minnesotans are depending on us, especially renters, are depending on us to make sure that we protect them from being displaced from their homes. Thank you.
You. I'm going to make a motion, but want to just also state the caveat that, as I did before, because we are past deadline, the motion is going to be for this bill to go to judiciary, but it also will make a stop in rules because it is past deadline. So with that, Senator Pa moves that Senate File 1671 as amended be recommended to pass and be referred to the Committee on Judiciary and Public Safety. All those in favor say aye. Aye. All those opposed say nay. Motion passes. Motion passes, and the bill is on its way. Thank you so much. All right. Thank you, members. Our next hearing is scheduled to be our last for this session. We will hear the governor's supplemental housing budget proposal and have our omnibus vehicle before us again to make some additions to it before we send it to the Finance Committee. And being at the end of our agenda, we are adjourned.